of the 1987 Constitution of the Republic of the Philippines, in Section 1, the legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives, except to the extent reserved to the people by the provision on initiative and referendum. In section number 2, the Senate shall be composed of 24 senators who shall be elected at large by the qualified voters of the Philippines, as may be provided by law. In section number 3, no person shall be a senator unless he is a natural born citizen of the Philippines and on the day of the election is at least 35 years of age, able to read and write, a registered voter, and a resident of the Philippines for not less than 2 years immediately preceding the day of the election. In section number 4, the term of office of the senators shall be 6 years and shall commence unless otherwise provided by law at noon on the 13th day of June next following their election. No senator shall serve for more than 2 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term of which he was elected. In section number 5, in section number 5, number 1 paragraph, the House of Representatives shall be composed of not more than 250 members unless otherwise fixed by law, who shall be elected from legislative districts, a portion among the provinces, cities, um, and the Metropolitan Manila area in accordance with the number of their respective inhabitants and on the basis of a uniform and progressive ratio in those who, as provided by law, shall be elected through a party list system of registered national, regional, and sectoral parties or organizations. So number 2 paragraph, the party list representatives shall constitute 20% of the total number of representatives, including those under the party list, for 3 consecutive terms after the ratification of this constitution. One half of the seats allocated to party list representatives shall be filed as provided by law by selection or election from the labor, peasant, urban poor, indigenous, cultural communities, women, youth, and such other sectors as may be provided by law, except the religious sector. And the paragraph 3, each legislative district shall comprise, as far as practicable, contiguous, compact, and adjacent territory. Each city with a population of at least 250,000 or each province shall have at least one representative. And paragraph number 4, within 3 years following the return of every census, the Congress shall make a reapportionment of the legislative districts based on the standards provided in this section. In section number 6, no person shall be a member of the House of Representatives unless he is a natural born citizen of the Philippines and on the day of the election is at least 25 years of age, able to read and write, and accept the party list registered voter in a district in which he shall be elected and a resident thereof for a period of not less than 1 year immediately preceding the day of the election. So in section number 7, the members of the House of Representatives shall be elected for a term of 3 years, which shall begin unless otherwise provided by law at noon on the 30th day of June next following their election. So no member of the House of Representatives shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. In section number 8, unless otherwise provided by law, the regular election of the senators and the members of the House of Representatives shall be held on the second Monday of May. And section number 9, in case of vacancy in the Senate or in the House of Representatives, a special election may be called to fill such vacancy in the manner prescribed by law, but the senator or member of the House of Representatives, those elected, shall serve only for the unexpired term. And section number 10, the salaries of senators and members of the House of Representatives shall be determined by law. No increase in said compensation shall take effect until after the expiration of the full term of all the members of the Senate and the House of Representatives approving such increase. In section 11, a senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years imprisonment, be privileged from arrest while the Congress is in session. No member shall be questioned nor be held liable in any other place for any speech or debate in the Congress or in any committee thereof. In section number 12, all members of the Senate and the House of Representatives shall, upon assumption of office, make a full disclosure of their financial and business interests. They shall notify the House concerned of a potential conflicts of interest that may arise from the filing of a proposed legislation of which they are authors. In section number 13, no senator or member of the House of Representatives may hold any other office or employment in the government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries during his term without forfeiting his seat. Neither shall he be appointed to any office which may have been created or the emoluments thereof increased during the term for which he was elected. And section number 14, no senator or member of the House of Representatives may personally appear as counsel before any court of justice or before the electoral tribunals or quasi-judicial and other administrative bodies. Neither shall he directly or indirectly be interested financially in any contract with or in any franchise or special privilege granted by the government or any subdivision agency or instrumentality thereof, including any government-owned or controlled corporation or its subsidiary. During his term of office, he shall not intervene in any matter before any office of the government for his pecuniary benefit or which he may be called upon to act on account of his office. In section number 15, the Congress shall convene once every year of the fourth Monday of July for its regular session unless a different date is fixed by law and shall continue to be in session for such number of days as it may be determined until 30 days before the opening of its next regular session, exclusive of Saturdays, Sundays, and legal holidays. So the President may call a special session at any time. So in section number 16, paragraph 1, the Senate shall elect its president in the House of Representatives, its speaker by a majority vote of all its respective members. Its house shall choose such other officers as it may deem necessary. A majority of each house shall constitute a quorum to do business, but a smaller number may be adjourned from day to day and may compel the attendance of absent members in such manner and under such penalties as such house may provide. In section number 3, in paragraph 3, each house may determine the rules of its proceedings, punish its members for disorderly behavior in the with concurrence of two-thirds of all its members, suspend or expel a member. A penalty of suspension when imposed shall not exceed 60 days. So in paragraph number 4, each house shall keep a journal of its proceedings and from time to time publish the same excepting such parts as may it and its judgment affect national security in the years and days or any question shall, at the request of the one-fifth of the members present, be entered in the journal. Each house shall also keep a record of its proceedings. So in section number 17, the Senate and the House of Representatives shall each have an electoral tribunal, which shall be a sole judge of all contests relating to the election, returns, and qualification of their respective members. Each electoral tribunal shall be composed of 9 members, 3 of whom shall be justices of the Supreme Court to be designated by the Chief Justice, and the remaining 6 shall be members of the Senate of the House of Representatives, as the case may be, who shall be chosen on the basis of proportional representation from the political parties and the parties or organizations registered under the party list system represented therein. The senior justice and the electoral tribunal shall be its chairman. In section number 18, there shall be a commission on appointments consisting of the president of the Senate as ex officio chairman, 12 senators, and 12 members of the House of Representatives elected by each house on the basis of proportional representation from the political parties and parties or organizations registered under the party list system represented therein. The chairman of the commission shall not vote except in case of a tie. The commission shall act on all appointments submitted to it within 30 session days of the Congress from their submission. The Commission shall rule by a majority vote of all members. And section number 19, the electoral tribunals and the Commission on Appointments shall be constituted within 30 days after the Senate and the House of Representatives shall have been organized with the election of the President and the Speaker. The Commission on Appointments shall meet only while the Congress is in session, at the call of its chairman or a majority of all its members, to discharge such powers and functions as are herein conferred. In section number 20, the records in books of accounts of the Congress shall be preserved and be open to the public in accordance with law. In such books shall be audited by the Commission on Audit, which shall publish annually an itemized list of amounts paid to and expenses incurred for each member. In section number 21, the Senate or the House of Representatives or any of its respective committees may conduct inquiries in aid of legislation in accordance with its duly published rules of procedure. The rights of persons appearing in or affected by such inquiries shall be respected. In section number 22, the heads of departments may, upon their own initiative, with the consent of the President, or upon the request of either House, as the rules of each House shall provide, appear before and be heard by such House on any matter pertaining to their departments. Written questions shall be submitted to the President of the Senate or the Speaker of the House of Representatives at least 3 days before their scheduled appearance. Interpellations shall not be limited to written questions, but may cover matters related thereto. When the security of the state or the public interest so requires, and the President so states in writing, the appearance shall be conducted in executive session. In section number 22, paragraph 1, the Congress by a vote of 2/3 of both houses in joint session assembled, voting separately, shall have the sole power to declare the existence of a state of war. In paragraph 2, in times of war or other national emergency, the Congress may by law authorize the President for a limited period and subject to such restrictions as it may prescribe to exercise powers necessary and proper to carry out a declared national policy. Unless sooner withdrawn by resolution of the Congress, such powers shall cease upon the next adjournment thereof. And section number 24, all appropriation revenue or tariff bills bill authorizing increase of the public debt, bills of local application, and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. In section number 25, paragraph 1, the Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. The form, content, and manner of preparation of the budget shall be prescribed by law. And paragraph 2, no provision or enactment shall be embraced in the general appropriation bill unless it relates specifically to some particular appropriation. Therein, any such provision or enactment shall be limited in its operation to the appropriation to which it relates. In paragraph 3, section number 25, the procedure in approving appropriations for the Congress shall strictly follow the procedure for approving appropriations for other departments and agencies. And paragraph 4, a special appropriations bill shall specify the purpose for which it is intended and shall be supported by funds actually available as certified by the National Treasurer or to be raised by a corresponding revenue proposal therein. And paragraph number 5, no law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, and the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions may, by law, be authorized to augment any item in the general appropriations law for the respective offices from savings in other items of the respective appropriations. And paragraph 6, section number 25, discretionary funds appropriated for particular officials shall be disbursed only for the public purposes to be supported by appropriate vouchers and subject to such guidelines as it may be prescribed by law. And paragraph 7, section number 25, if by the end of any fiscal year, the Congress shall have failed to pass the General Appropriations Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the general again. And paragraph 7 of section number 25, if by the end of any fiscal year, the Congress shall have failed to pass the General Appropriation Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the General Appropriation Bill is passed by the Congress. In section number 26, paragraph 1, every bill passed by the Congress shall embrace only one subject which shall be expressed in the title thereof. And paragraph 2, no bill passed by either house shall become a law unless it has 3 readings on separate days and printed copy the necessity of its immediate enactment to a public calamity. Upon the last reading of a bill, no amendment thereto shall be allowed, and the vote thereon shall be taken immediately thereafter, and the yeas and nays entered in the journal. And section number 27, paragraph 1, every bill passed by the Congress shall, before it becomes a law, be presented to the President. If he approves the same, he shall sign it; otherwise, he shall veto and return the same with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. If after such reconsideration 2/3 of all the members of such house shall agree to pass the bill, it shall be sent together with the objections to the other house, by which it shall likewise be reconsidered, and if approved by 2/3 of all members of that house, it shall become a law. In all such cases, the votes of each house shall be determined by yeas or nays, and the names of the members voting for or against shall be entered in its journal. The president shall communicate his veto of any bill to the House where it originated within 30 days after the date of receipt thereof. Otherwise, it shall become a law as if he had signed it. And paragraph number 2, the president shall have the power to veto any particular item or items in an appropriation, revenue, or tariff bill, but the veto shall not affect the item or items to which he does not object. In section number 28, the rule of taxation. In section number 28, paragraph 1, the rule of taxation shall be uniform and equitable. The Congress shall evolve a progressive system of taxation. In paragraph 2, the Congress may by law authorize the president to fix within specified limits and subject to such limitations and restrictions as it may impose tariff rates, import and export quotas, tonnage and wharfage dues, and other duties or imposed within the framework of the National Development Program of the government. And paragraph 3, charitable institutions, churches, and personages or convents appertinent thereto, mosques, non-profit cemeteries in all lands, buildings, and improvements actually, directly, and exclusively used for religious, charitable, or educational purpose shall be exempted from taxation. And paragraph 4, no law granting any tax exemption shall be passed without the concurrence of a majority of all the members of the Congress. In section number 29 of the Legislative Department, in paragraph 1, no money shall be paid out of the treasury except in pursuance of appropriation made by law. So, in paragraph 2, no public money or property shall be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support of any sector, charge, denomination, secretarial, institution, or system of religion, or of any priest, preacher, minister, other religious teacher, or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces or to any penal institution or government or panage or leprosarium. And paragraph number 3, on any tax levied for a special purpose shall be treated as a fund and paid out for such purpose only. If the purpose for which the special fund was created has been fulfilled or abandoned, the balance, if any, shall be transferred to the general funds of the government. So in section number 30 of the Legislative Department, no law shall be passed increasing the appellate So again, in section number 30 of the legislative power, section number 30, no law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided in this Constitution without its advice and concurrence. And section number 31, no law granting a little of royalty or nobility shall be enacted. And section number 32, the Congress shall, as early as possible, provide for a system of initiative and referendum. And the exception therefrom whereby the people can directly propose and enact laws or approve or reject any act or law or part thereof passed by the Congress or local legislative body after the registration of a petition, therefore signed by at least 10% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters thereof. Okay. In Article 7 of the Executive Department, Section 1, the executive power shall be vested in the President of the Philippines. And Section number 2, no person may be elected President unless he is a natural born citizen of the Philippines, a registered voter right at least 40 years of age of the day of the election, and a resident of the Philippines for at least 10 years immediately preceding such election. In section number 3, there shall be, and in the same manner as the President, he may be removed from office in the same manner as the President. So the Vice President may be appointed as a member of the Cabinet. Such appointment requires no confirmation. And section number 4, the President and the Vice President shall be elected by direct vote of the people for a term of 6 years, which shall begin at noon on the 30th day of June next following the day of the election, and shall end at noon of the same date. 6 years thereafter, the President shall not be eligible for any re-election. No person who has succeeded as president and has served as such for more than 4 years shall be qualified for election to the same office at any time. So no president or no vice president shall serve for more than 2 successive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the of the service for the full term for which he was elected. Unless otherwise provided by law, the regular election for president and vice president shall be held on the second Monday of May. So the returns of every election for President and Vice President duly certified by the Board of Canvassers of each province or city shall be transmitted to the Congress, directed to the President of the Senate upon receipt of the certificates of canvass. The President of the Senate shall, not later than 30 days after the day of the election, open all certificates in the presence of the Senate and the House of Representatives in joint public session in the Congress upon determination of the authenticity and due execution thereof in the manner provided by law, canvass the votes. So the person having the highest number of votes shall be proclaimed elected. But in case two or more shall have an equal in highest number of votes, one of them shall forthwith be chosen by the vote of a majority of all the members of both houses of the Congress, voting separately. So the Congress shall promulgate its rules for the canvassing of the certificates. So the Supreme Court sitting in bank shall be the sole judge of all contests relating to the election, returns, and qualification of the president or vice president, and may promulgate its rules for the purpose. And section number 5 of Executive Department, before they enter the execution of their office, the president, the vice president, or the acting president shall take the following oath or affirmation. I do solemnly swear that I will faithfully and conscientiously fulfill my duties as president or vice president or acting president of the Philippines, preserve and defend its constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. So help me God. In section number 6, the president shall have an official residence. The salaries of the president and the vice president shall be determined by law and shall not be decreased during their tenure. No increase in said compensation shall take effect until after expiration of the term of the incumbent, during which such increase was approved. they shall not receive during their tenure any other emolument from the government or any other source. In section number 7 of the executive department, the president-elect and the vice president-elect shall assume office at the beginning of their terms. If the president-elect fails to qualify, the vice president-elect shall act as president until the president-elect shall have qualified. So if a president shall not have been chosen, the vice president-elect shall act as president until a president shall have been chosen and qualified. If at the beginning of the term of the president-elect shall have died or shall have become permanently disabled, the vice president-elect shall become president. So, where no president and vice president shall have been chosen or shall have qualified, or where both shall have died or become permanently disabled, the president of the Senate, or in case of his inability, the Speaker of the House of Representatives, shall act as president until a president or a vice president shall have been chosen and qualified. The Congress shall, by law, provide for the manner in which one who is to act as president shall be selected until a president or a vice president shall have qualified in case of death, permanent disability, or inability of the officials mentioned in the next preceding paragraph. And section number 8 of Executive Department, in case of death, permanent disability, removal from office, or resignation of the president, the vice president shall become the president to serve the unexpired term. So, in case of death, permanent disability, removal from the office, or resignation of both the president and vice president, the president of the Senate, or in case of his inability, the Speaker of the House of Representatives shall then act as president until the president or vice president shall have been elected and qualified. The Congress shall by law provide who shall serve as president in case of death, permanent disability, or resignation of the acting president. He shall serve until the president or the vice president shall have been elected and qualified and be subject to the same restrictions of powers and disqualification as the acting president. Section number 9, whenever there is a vacancy in the office of the vice president during the term for which he was elected, the president shall nominate a vice president from among the members of the Senate and the House of Representatives who shall assume office upon confirmation by a majority vote of all the members of both houses of the Congress, voting separately. In section number 10 in Executive Department, the Congress shall at 10 o'clock in the morning of the third day after the vacancy in the offices of the president and the vice president, of course, convenes in accordance with its rules without need of a call, and within 7 days enact a law calling for a special election to elect a president and a vice president to be held not earlier than 45 days, not later than 60 days from the time of such call. The bill calling such special election shall be deemed certified under paragraph 2, section 26, articles 6 of this Constitution, and shall become law upon its approval on third reading by the Congress. So appropriations for the special election shall be charged against any current appropriations and shall be exempted from the requirements of the paragraph 4 of section number 25, article 6 of this Constitution. The convening of the Congress cannot be suspended nor the special election postponed. No special election shall be called if the vacancy occurs within 18 months before the date of the next presidential election. In Section 11 of the Executive Department, whenever the President transmits to the President of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. So whenever a majority of all the members of the cabinet transmit to the President of the Senate and to the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers. Again, whenever a majority of the cabinet transmit to the President of the Senate and written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office of the acting President. So thereafter, when the President transmits to the President of the Senate and to the Speaker of the House and the Speaker of the House of Representatives his written declaration that no inability exists, he shall reassume the powers and duties of his office. Meanwhile, should a majority of all the members of the cabinet transmit within 5 days to the President of the Senate and to the Speaker of the House of Representatives the written declaration that the President is unable to discharge the powers and duties of his office, the Congress shall decide the issue. For that purpose, the Congress shall decide the issue. For that purpose, the Congress shall convene if it is not in session within 48 hours in accordance with its rules and without need of call. So if the Congress within 10 days after receipt of last written declaration or if not in session within 12 days after it is required to assemble determines by a two-thirds vote of both houses voting separately that the President is unable to discharge the powers and duties of his office, the Vice President shall act as President. Otherwise, the President shall continue exercising the powers and duties of his office. In Section 12, in Section 12 of the Executive Department, in case of serious illness of the President, the public shall be informed of the state of his health. The members of the cabinet in charge of national security and the foreign relations and the chief of staff of the armed forces of the Philippines shall not be denied access to the president during such illness. And section number 13, the president, vice president, and the members of the cabinet and their deputies or assistants shall not, unless otherwise provided in this constitution, hold any other office or employment during their tenure. They shall not during said tenure directly or indirectly practice any other profession, participate in any business, or be financially interested in any contract with or any franchise or special privilege granted by the government or any subdivision instrumentality thereof, including government-owned or controlled corporations or their subsidiaries. They shall strictly avoid conflict of interest in the conduct of their office. So the spouse and relatives by consanguinity or affinity within the fourth civil degree of the president shall not, during his tenure, be appointed as members of the Constitutional Commission or the office of the Ombudsman or as secretaries, undersecretaries, chairmen, or heads of various of offices including government-owned or controlled corporations and their subsidiaries. And section number 14 of Executive Department, appointments extended by an acting president shall remain effective unless revoked by the elected president within 90 days from his assumption or reassumption of office. In section number 15, of Executive Department 2 months immediately before the next presidential elections and up to the end of his term, a president or acting president shall not make appointments except temporary appointments to executive positions when continued vacancies therein will prejudice public service or endanger public safety. And section number 16 of Executive Department, the President shall nominate and with the consent of Commission of Appointments, appoint the heads of executive departments, ambassadors, other public ministers in consuls, or officers of the armed forces of the rank uh, or officers again. In section number 16 of Executive Department, the President shall nominate and with the consent of COA or the Commission on Appointments, appoint the heads of executive departments, ambassadors, other public ministers in consuls or officers of the armed forces from the rank of colonel or naval captain, and other officers whose appointments are vested in him and this constitution. He shall also appoint all other officers of the government whose appointments are not otherwise provided for by law, and those whom he may be authorized by law to appoint. So the Congress may by law vest in appointment of other officers lower in rank in the president alone. So in the courts or in the heads of departments, agencies, and commission or boards, the president shall have the power to make appointments during the recess of the Congress, whether voluntary or compulsory, but such appointments shall be effected only until disapproved by the Commission on Appointments or until the next adjournment of the Congress. In section number 17 of Executive Department, the President shall have control the President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. In section number 18 of Executive Departments, the President shall be the Commander-in-Chief of all armed forces of the Philippines, and whenever it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion, or rebellion. In case of invasion or rebellion, when the public safety requires it, he may for a period not exceeding 60 days suspend the privilege of the writ of habeas corpus or place of the Philippines or any part thereof under martial law within 48 hours from the proclamation or of martial law or the suspension of the privilege of the writ of habeas corpus. The President shall submit a report in person or in writing the Congress. The Congress voting jointly by a vote of at least a majority of all its members in regular or special session may revoke such proclamation or suspension, which revocation shall not be set aside by the President upon the initiative of the President. The Congress may, in the same manner, extend such proclamation or suspension for a period to be determined by the Congress if the invasion or rebellion shall persist and public safety requires it. So the Congress, if not in session, shall within 24 hours following such proclamation or suspension convene in accordance with its rules without need of a call. So the Supreme Court may review in an appropriate proceeding filed by any citizen the sufficiency of the factual basis martial law or the suspension of the privilege of the writ of habeas corpus or the extension thereof, and must promulgate its decision thereon within 30 days from its filing. So a state of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or legislative assemblies, nor authorize the conferment of jurisdiction on military courts and agencies over civilians, where civil courts are able to function, nor automatically suspend the privilege of the writ of habeas corpus. So the suspension of the privilege of the writ of habeas corpus shall apply only to persons judicially charged for rebellion or offenses inherent in or directly connected with invasion. So during the suspension of the privilege of the writ of habeas corpus, any person thus arrested or detained shall be judicially charged within 3 days, otherwise he shall be released. And section number 9 of Executive Department, except in cases of impeachment or as otherwise provided in the Constitution, the President may grant reprieve, commutations and pardons and remit fines and forfeitures after conviction by final judgment. He shall also have the power to grant amnesty with the concurrence of a majority of all the members of the Congress. In section number 20 of the executive departments, the President may contract or guarantee foreign loans on behalf of the Republic of the Philippines with the prior concurrence of the Monetary Board and subject to such limitations as may be provided by law. The Monetary Board shall, within 30 days from the end of every quarter of the calendar year, submit to the Congress complete a report of its decision on applications for loans to be contracted or guaranteed by the government or government-owned and controlled corporations, which would have the effect of increasing the foreign debt and containing other matters as may be provided by law. In section number 21, no treaty or international agreement shall be valid and effective unless concurred in by at least two-thirds of all members of the Senate. In section number 22, the President shall submit to the Congress within 30 days from the opening of every regular session as the basis of the General Appropriations Bill, a budget of expenditures and sources of financing, including receipts from existing and proposed revenue measures. And section number 28 and Executive Department in section number 23 in Executive Department, the President shall address the Congress at the opening of its regular session. He may also appear before it at any other time. Okay, that's all. Thank you.